Hello, my name is Erica de Benedict. This is week 3 case study, which is creating a department process for subpoena request. So Montgomery City Hospital has a large ambulatory care facility, and it includes clinical staff, which includes 10 multidisciplinary physicians, 3 mid-level providers, and support staff. In addition, the facility also has mental health, radiology, laboratory, and nutritional services. The Director of Health Information Management also serves as the custodian of health records, and they have been facing difficulty responding to subpoenas when it comes to patient health records in the facility. The current process for the facility of converting from paper-based to electronic health record system, and also some records are available in hybrid formats. The current process of finding and identifying various parts of the patient records from different sources of a subpoena request is not documents, is time-consuming, and is inconsistent. In order to resolve inconsistencies, a department process for subpoena requests will be created, and this will include steps for employees to follow. So the issues of the current process include some of the information is on paper. Some of the documents, which includes consents and HIPAA release documents. In addition, there's also some information which is scanned immediately following discharge. And that can include notes such as nursing notes, which are scanned into the EHR. Another issue is that some information is automatically, which is considered cold, which is fed into the EHR system. So that includes like reports, transcription reports, which automatically get saved into the EHR system. And then some information is only stored within electronic systems. So this includes records such as lab reports, results, and physician orders. So there's a lot of inconsistencies. Not everything is centralized or uniform, whereas everything is on an EHR system. Everything is found in different places. So the proposed process includes the first step, which is the initial receipt of a subpoena request. So when a subpoena request is received, the HIM department should first verify the authenticity of the subpoena with the legal department and work with counsel to ensure it complies with not only state but also federal regulations such as the HIPAA Act. And when it comes to state, Connecticut laws governing the release of medical records. So, for example, in Connecticut, subpoenas cannot be served less than 24 hours before the time for production and no more than 2 weeks in time, according to JUSTIA. The next step would be the identification of relevant health records. The HIM department will begin the process of identifying and gathering relevant health records based on the following locations and types. So for paper-based records, the first step would be to locate and retrieve paper-based records that are stored in the designated filing areas, and also make sure that any consents or HIPAA release forms are included in the response. For scanned records, in order to access the health record system and to retrieve the scanned notes, it's important to verify the completeness and accuracy of notes before including them in response to the subpoena. So you never want to send anything incomplete. Everything wants to be complete and accurate. For records that are automatically fed into the EHR system, it's important to access the EHR system and retrieve reports and other records that are fed into the system. And once again, it's important to confirm the authenticity and the completeness of the reports. For electronic-only records, when accessing the EHR system and retrieving these records, once again, you have to ensure all of the results are relevant and the orders are included in the response and they're all related to the subpoena request. The next step would be a review and compliance check, so conducting a thorough review of all the health records that are collected to once again ensure compliance with state and federal regulations regarding PHI disclosure. So in Connecticut, HIPAA protects entities to disclose PHI without a patient's written authorization to certain public health authorities for public health activities, in cases for workers' compensation cases, and certain law enforcement purposes, and any judicial or administrative proceedings. Based on my experience too, say if it's a workers' compensation claim or legal proceedings, many times, even though the hospital does not have their own written authorization from a patient. Many times when a patient has legal counsel, they have their own documentations where they allow for authorization. Obviously, in a sense where it's a subpoena, that's a different kind of matter. But when it comes to workers' compensation and the other matters mentioned, they are protected in that sense. And once again, it's important to view the accuracy, completeness, and authenticity of the documents before proceeding. So for the fourth step, it's compilation and organizing the records. So it's important to organize the records in a comprehensive manner, so chronological. This way it's easy to review from the requesting party, and the requesting party can go from the earliest date to the latest date. And also important to ensure proper labeling and index the records. So it's important to keep everything labeled and accurate. This way, when they're labeled and there's an index, they can see if there's anything that might be needed before even going through it, which makes it a lot easier. The next is the redaction of protected information. So it's important this is probably the most important step because it's important to identify and redact any PHI that's not relevant to subpoena requests and is otherwise protected from disclosure under HIPAA regulations. So it's important to, in addition to redacting, also documenting the redaction process and why each item that was redacted wasn't redacted. Then, the submission of the response, which is the submission of the subpoena. So before it gets submitted, it's important to, once again, prepare the health records with a cover letter that provides necessary context and explanations. You could also mention in the cover letter what's included. In Connecticut, a provider must provide a health record within 30 days of subpoena request. So this is the flow diagram, which shows, the first step is receiving the subpoena request and identifying the health records, and then whether it's paper-based, whether it's scanned or automatically scanned to the EHR system, or if it's electronic only, then it provides you with the next necessary steps. So in conclusion, the process for the subpoena response is designed to ensure compliance not only with the Health Insurance Portability and Accountability Act, Connecticut state-specific medical record retention and release laws, and also court rules and procedures that govern subpoenas for health records. So by adhering to this process, Montgomery City Hospital aims to protect patient confidentiality, maintain legal compliance and responses in an efficient and accurate manner to subpoena requests that pertain to patient records. And that is all for today. Thank you.